Usually when we talk about a legal system, there's this expectation of like extreme rigidity. I mean, I always picture a skyscraper.
Oh, right, like a massive static building.
Exactly. You look at the blueprints, you see the steel girders, the concrete foundation, and the architect just points and says, there it is. It's built. It doesn't change.
Yeah, it's set in stone. You can lean against it and trust it's not going to just suddenly move on you.
Right. You pass a law, you print it in a massive, thick, leather-bound book, and it just sits there on a judge's desk.
But that is definitely not the case here.
No, not at all. When you step into the architecture of Muslim law, especially as it operates in a really complex, multi-religious society like India, suddenly that static blueprint starts shifting right in front of your eyes.
It really does. It adapts.
It does. So you are about to embark on a fascinating journey into the architecture of a major legal system today. We're looking at a legal landscape that is alive, constantly evolving, and honestly, incredibly complex.
It is the absolute definition of a living, breathing jurisprudence. And, to really grasp it, you have to abandon the idea that law is just a list of rules.
Yeah.
It is a highly sensitive organism that reacts to history, to geography, and to the deep-seated beliefs of the people it governs.
Okay, let's unpack this. I mean, how do you build a legal framework that bridges absolute divine commandments with the chaotic, messy realities of modern secular courts?
They're a massive challenge.
It is. How do you take a 7th century text and use it to settle a 21st century dispute over a tech entrepreneur's inheritance or like a cross-border divorce?
Right.
That is the mission of this deep dive. We're going to look at how this massive system actually operates on the ground. We're going to trace the origins, break down the different schools of thought, and look at the very real friction points.
Things like marriage, conversion, and the actual enforcement of these rights.
Exactly.
What's fascinating here is the sheer plurality of it all. I mean, Muslim law is not monolithic, not even close.
Right. People tend to think it is, though.
They do, but it is characterized by incredible diversity and continuous evolution. It's a system where classical religious texts are in a constant, dynamic conversation with modern state apparatuses.
Like the Indian Constitution, for example.
Precisely. And we need to look at this not just as abstract legal theory, but as a framework that regulates the most intimate aspects of human life for millions of people.
It's amazing. But before we can understand how an Indian family court judge applies this law today, we really have to go back to the original blueprint.
We have to start at the foundation.
Yeah, because where do these rules actually come from?
Yeah.
You can't understand a building without knowing the materials it's made of. So let's start with the absolute foundation, the primary sources of Islamic jurisprudence.
Right. So the materials are broadly divided into two categories. You have your primary sources, which are considered divine or directly linked to the Prophet Muhammad, and then your secondary sources.
Which are more human, right?
Exactly. The secondary sources are the human, regional, and evolving adaptations of those primary rules.
Okay, that makes sense. And the very first primary source, like the ultimate foundational pillar, is the Quran.
The divine text itself, yes.
But here is the thing that completely stopped me in my tracks when I first learned about this. Out of the thousands of verses in the entire text of the Quran, only about 80 verses deal strictly with legal matters. 80!
Yeah, it is a surprisingly small number when you consider the vastness of Islamic law.
It's staggering.
Yeah.
Just 80 verses to govern marriage, divorce, inheritance, contracts, crimes, everything.
It seems impossible, doesn't it?
It really does. That's like trying to build a modern, complex computer operating system with just a few dozen lines of core code.
That's a great way to put it.
If I'm an empire builder, or even just a local judge in the 8th century, 80 verses is a recipe for total chaos when a novel dispute walks through my door. How does that possibly work?
Well, you have to understand the nature of those 80 verses. They aren't, granular day-to-day administrative instructions.
Oh, okay. So they aren't super specific.
Right. They are overarching, unchangeable principles. The Quran provides the absolute moral and legal boundaries. It tells you the what and the why of justice.
But it leaves a lot of the how out.
Exactly. It leaves the how to be worked out by the community. Because human life is infinitely complex, those 80 verses fundamentally required explanation, context, and practical demonstration.
Which naturally leads us to the second primary source, the Sunnah. And that includes the Hadith, right?
Yes, exactly. If the Quran is the divine message, the Sunnah is the messenger's practical daily application of it.
So it's seeing it in action.
Precisely. The Sunnah encompasses the practices, the sayings, and the silent approvals of Prophet Muhammad.
I'm going to pause on that phrase for a second, silent approvals, because it's such an interesting legal concept. What does that actually mean in practice?
It means that if an action was taken in the prophet's presence, or a dispute was settled in a certain way in his community, and he did not object to it, his silence is legally interpreted as tacit approval.
Oh, wow. Just not saying no means yes.
In that specific context, yes. It essentially grandfathers in certain existing pre-Islamic Arab customs that weren't contrary to the new divine message.
Okay, that makes total sense. So the prophet's life acts as the ultimate context for the Quran's 80 legal verses.
Exactly. He explains how to live out those commands.
Like how to resolve a property dispute or how to conduct a marriage.
Right, the practical everyday stuff.
So together, the Quran and the Sunnah form the absolute bedrock of the law. But again, society moves forward.
It always does.
The prophet passes away, the empire expands into Persia, into North Africa, and suddenly you have entirely new problems.
Vastly different economies, agricultural systems, different cultures.
Yeah, things that simply didn't exist in 7th century Arabia.
And this is where Islamic jurisprudence shows its incredible architectural brilliance. It anticipated the need for human reasoning.
Right.
And that brings us to the third primary source, ijma.
Ijma, the consensus of the learned scholars and jurists of Islam. So when the Quran and the Sunnah are totally silent on a brand new issue, the scholars get together, and if they reach a unified opinion, that opinion gains binding legal weight.
Yes, it's a collective reasoning process. It acknowledges that the community of scholars, deeply steeped in the foundational texts, can arrive at a binding legal truth for their specific era.
Here's where it gets really interesting for me, though. How do you actually achieve consensus in a pre-internet world?
It's a logistical nightmare.
Right. You have scholars in Spain, scholars in Baghdad, scholars in Damascus. Are we talking about a literal convention where they all vote?
That is actually the great historical debate within Islamic jurisprudence. How do you practically verify ijma?
Because it seems impossible.
In the very early days, when the community was just the Prophet's companions living in Medina, consensus was literal and physical. You could just ask everyone.
Because they were all in one place.
Exactly. But as the Islamic world expanded from Spain to India, absolute universal consensus became practically impossible. So ijma evolved.
How so?
It became more about the consensus of the leading scholars of a specific era or even a specific geographical region.
Okay.
If a legal ruling was published and widely circulated, and no major scholar of that generation publicly refuted it, it was deemed to have achieved ijma.
Okay, let me try an analogy here to see if I'm tracking this. If the Quran and the Sunnah are the core operating system of a computer, is ijma essentially like an open-source developer consensus?
I like where you're going with this.
Like where all the top programmers globally agree on how a new software feature should work, and once they all co-sign it, it becomes the official update.
That is a phenomenal analogy. Yes, ijma is that peer-reviewed consensus that ensures the system doesn't splinter into a million contradictory directions.
It keeps it unified.
Exactly. But to actually build that new feature, those developers need a specific tool. And that tool is the fourth primary source, qiyas, or analogical reasoning.
Qiyas. Taking principles from the Quran and Sunnah and mathematically extending them to new situations.
Right, but it's a very strict, highly regulated form of logic. You can't just make an analogy because you feel like it.
You can't just guess.
No. You have to identify the underlying reason for an original divine ruling. This is called ilat, or the ratio decidendi.
Right. So if we take an old constitutional principle, like freedom of speech written for printing presses, and apply it to a brand new technology, like the internet, we are doing a form of modern qiyas.
Precisely. Let's look at the classic historical example used to teach qiyas. The Quran explicitly forbids the consumption of wine. That is the original text.
Okay.
Centuries later, a new intoxicant appears, say, a specific type of narcotic. The Quran doesn't mention narcotics. So the jurist asks, what is the ilat, the root cause of the ban on wine?
It's the intoxicating effect, the fact that it alters the mind.
Exactly. The intoxication is the ilat. Since the narcotic shares that exact same underlying characteristic, the ruling of prohibition is logically extended to the new substance through qiyas.
Wow. Okay, so we have our four massive pillars. The divine text, which is the Quran, the prophet's application, the Sunnah, the scholarly consensus, ijma, and analogical reasoning, qiyas.
Correct.
But if we stop there, the system is still pretty theoretical. We have to look at the secondary sources.
Yes, the more terrestrial, localized tools.
Right, the tools that actually ground the law in reality.
Yes, the human element of legal evolution. And the first of these secondary sources is custom, or urf,
Local customs. Now, I know what you're thinking. Wait, doesn't a divine law completely override local customs?
It's a common misconception.
But it's actually much more nuanced, right? Local customs are recognized by Islamic jurists, but only if they do not contradict the primary Islamic principles.
Right. IRF acts as a localized adaptation mechanism. It's an acknowledgement that you cannot govern an agrarian society in Egypt the exact same way you govern a mercantile society in the Levant.
That makes total sense.
For example, if a specific local market has a customary way of determining the fair price of goods or a traditional timeline for paying business debts, Islamic law will adopt that custom as legally binding.
Because it helps the community function.
Exactly, provided it doesn't involve charging interest, which is expressly forbidden by the primary sources.
But if a local village has a custom of, say, completely denying women their inheritance rights to keep land within the male bloodline, that custom is immediately thrown out.
Yes, instantly.
It's void because the Quran explicitly grants fixed inheritance rights to women.
Precisely. Custom provides the flavor, but the primary sources provide the nutritional constraints.
I love that.
And then, as we move into the modern era, particularly in India, we encounter two massive secondary sources that dictate almost everything happening in courtrooms today.
Judicial decisions and legislation. Let's talk about judicial decisions. How Indian courts interpret Muslim personal law. Because the judges in India, going all the way back to the British Privy Council, up to today's Supreme Court, they are essentially shaping the law through precedent.
They are, and it's a remarkably complex task. Indian courts rely on classical Islamic commentaries.
Like what?
Massive tomes like the Hidayah or the Fatawi-i-Alamgiri, which was compiled under the Mughal Emperor Aurangzeb.
Right.
But the modern secular judge has to interpret these medieval texts through the lens of modern evidence acts, modern civil procedure, and constitutional rights.
Which sounds incredibly difficult and often requires the state to just step in and pass an actual law to clear things up.
Exactly.
That's our final secondary source legislation.
Right.
Statutory interventions by the state.
Yes. While Muslim law in India is primarily uncodified, meaning it's not all neatly written down in one single government act, the state has stepped in at crucial moments.
A major historical example is the Muslim Personal Law Application Act of 1937.
Right. Yes, the Shariat Act. That act was pivotal. Before 1937, many Muslim communities in India, particularly agricultural communities in Punjab, were following local customary law regarding inheritance.
Which wasn't always fair.
Right. It often excluded women entirely, rather than following Islamic law. The 1937 Act legally mandated that in matters of family and inheritance, Muslims in India would be governed strictly by Muslim personal law,
So it forced them back to the primary texts.
effectively overriding those discriminatory local customs and restoring the Quranic rights to women in those regions.
And then we have very recent, very impactful legislation, like the Muslim Women Protection of Rights on Marriage Act in 2019.
Yes.
This is the statute that outlawed instant triple talaq in India. It really is. So why is it so important for you, the listener, to understand this entire spectrum of sources?
Because it proves that Islamic jurisprudence is not frozen in time. It is not that static blueprint we talked about earlier.
Right.
It has built-in, sophisticated mechanisms like qiyas, for analogy, and urf, for custom to adapt to entirely new human situations. It shows a legal framework designed to stretch and accommodate progress while remaining tethered to its fundamental origins.
But here's the catch. We have this beautiful, complex machinery of sources. But if you give the exact same source code to different teams of developers, they're going to build wildly different applications.
Yeah, literally.
They're going to prioritize different features based on their environment. And that perfectly explains how we ended up with the different schools of Muslim law. Which brings us to the branching paths.
This is where the plurality of Muslim law becomes incredibly apparent and, frankly, very tricky for a modern judge.
Yeah, I can imagine.
Broadly speaking, the law is divided into two major sects, Sunni and Shia. And within those sects, you have distinct schools of thought, or madhabs.
Let's tackle the Sunni sect first. Sunni Muslims constitute the vast majority of the global Muslim population, and that holds true in India as well.
Yes.
And within Sunni law, there are four main sub-schools. Let's start with number one, which is arguably the most important for our context, the Hanafi school.
Founded by Imam Abu Hanifa in the 8th century, this is by far the most widespread school globally, and it is the dominant school followed by the vast majority of Sunni Muslims in South Asia, including India.
So what is its defining characteristic? Like, why did this specific school become so massive?
To understand the Hanafi school, you really have to understand where it was born. Abu Hanifa lived in Kufa in modern-day Iraq.
Oh.
At the time, Kufa was a bustling, cosmopolitan, highly diverse metropolitan hub. It was a center of trade where Arabs, Persians, and people from all over the empire mixed.
Right, so he wasn't operating in a small, homogeneous desert town. He was dealing with complex commercial disputes, diverse cultures, and just unprecedented social issues.
Exactly. Because of that environment, the Hanafi school is characterized by its extraordinary flexibility. It places a heavy reliance on reason, or ray, and a principle called istisan,
Istisban.
which translates to juristic preference.
Juristic preference. Let me see if I can translate that for a second. Does that mean a judge can look at a strict analogical ruling? A Kias decide that applying it strictly would cause unnecessary hardship or be deeply unfair in this specific case, and just choose a different, more equitable ruling instead.
That is precisely what it means.
Wow.
It allows the jurist to bypass a strict analogy if it leads to an unjust outcome, preferring a ruling that aligns better with the broader objectives of Islamic law, which include public welfare and ease.
So it's very pragmatic.
Extremely pragmatic. It makes the Hanafi school highly adaptable to different cultures, which is exactly why it spread so successfully across the Ottoman and Mughal empires.
That makes total sense. Environment dictates the law. Which brings us to the second Sunni school, the Maliki school, founded by Imam Malik. Now, he was based in Medina, the Prophet's city.
And his environment dictated a totally different approach. Medina was historically homogenous. It was the cradle of the religion.
Right.
So Imam Malik's philosophy was deeply geographically anchored. He emphasized the practices of the people of Medina as a fundamental source of law.
So his logic was essentially, we don't need complex analogical reasoning to figure out what the Prophet would have wanted. The Prophet lived here.
Exactly.
We are the grandchildren of his companions. The way our market operates, the way our families function, our daily practice inherently reflects his teachings.
Yes. It's a beautifully simple, historically grounded approach. If the people of Medina historically performed a contract in a certain way, Imam Malik viewed that collective, unbroken practice as carrying almost the weight of a hadith.
Wow, that's powerful.
Yeah.
And where is that school most common today?
Today, the Maliki school is prevalent across North and West Africa.
Okay, third is the Shafi'i school, founded by Imam al-Shafi'i, practiced heavily in East Africa and Southeast Asia, places like Indonesia and Malaysia. Now, from what I understand, al-Shafi'i is basically the supreme architect of legal theory.
He really was a revolutionary systematizer. Before al-Shafi'i, the methodology of using the sources was a bit fluid.
Right.
You had the Hanafi scholars leaning heavily into reason and the Maliki scholars leaning heavily into tradition. Al-Shafi'i stepped in and created the definitive methodological rulebook.
He standardized it.
He rigidly structured exactly how the Quran, Sunnah, Ijma, and Qiyas interact with each other. He argued that human reason cannot operate freely, it must be strictly bound by the texts.
Wait, if the Shafi'i school locked in the methodology so strictly, didn't that freeze the law in place?
It's an excellent question.
Like, how does a Shafi'i judge deal with a modern issue like cryptocurrency if the methodology is so rigid?
It didn't freeze the law, but it severely disciplined it. A Shafi'i jurist today looking at cryptocurrency cannot just use istisan and say, well, it seems good for the economy, let's allow it.
Like the Hanafi school might.
Right. They have to perform a highly rigorous, textually bound qiyas. They have to find a direct analogy to rules regarding the exchange of gold, silver, or fiat currency in the hadith and map the ilat perfectly.
Oh.
It's a much more demanding intellectual exercise that leaves less room for subjective judicial preference.
Fascinating. And finally, the fourth Sunni school, the Hanbali school, founded by Imam Ahmad ibn Hanbal. This is the most conservative school dominant today in Saudi Arabia.
Yes. The Hanbali school emerged slightly later, largely as a reaction against what they saw as the excessive use of human reasoning by the earlier schools.
They wanted to get back to basics.
They rely on a strict, literal interpretation of the text. They're deeply skeptical of human logic taking precedence over scripture, so that they have far less reliance on analogy or qiyas.
They just stick to the text.
An intense, almost exclusive focus directly on the Quran and the hadith. If there is a weak hadith on a subject, a Hanbali jurist will often prefer that weak text over the strongest, most logical human analogy.
Wow. Okay, so that is the Sunni side. 4 distinct flavors, shaped by history and geography, ranging from the highly flexible Hanafi to the strictly literal Hanbali.
Yes.
Now, let's pivot to the Shia sect, We know they have different legal interpretations, but what is the fundamental historical split here? Because the split dictates the law.
The historical and theological split stems entirely from the crisis of succession after the Prophet Muhammad passed away.
Right.
Shia Muslims have a distinct legal framework because they reject the political and religious authority of the first three caliphs. They believe that leadership, and therefore ultimate legal interpretive authority, should have remained strictly within the Prophet's bloodline.
Specifically starting with his cousin and son-in-law, Ali.
Yes.
And how does that political split change the actual legal machinery?
It changes the transmission of the primary sources. For Shia jurisprudence, a hadith, a saying of the Prophet, is generally only considered authentic and binding if it was transmitted through the lineage of the Prophet's family, the Imams.
Okay, so they reject many of the narrators that the Sunni schools rely on.
Yes.
So they literally have a different database of primary texts to work from.
Exactly. It's a completely different foundational library in many respects. And the most prominent Shia school, representing the vast majority of Shia Muslims in places like Iran, Iraq, and parts of India, is the Isna Ashari, or the Twelvers.
The Twelvers.
They follow the Jafari school of jurisprudence.
And they are called Twelvers because they recognize 12 divinely ordained imams.
Yes. And the Jafari school, founded by the sixth Imam, Jafar al-Sadiq, is unique. It places a massive, profound importance on the sayings and legal rulings of those Imams.
Treating them essentially as a primary source of law alongside the Quran.
Exactly. Interestingly, while they are deeply anchored in the authority of the Imams, the Jafari school also utilizes a highly rationalist approach to legal deduction called aql, or intellect.
Which functions somewhat differently than Sunni qiyas.
Yes, it's a distinct philosophical approach to reason.
There are also smaller Shia branches, right? Like the Ismaili, who have a more esoteric interpretation of the texts.
Yes.
And the Zaydi, primarily in Yemen, who are actually closer to Sunni law in their everyday jurisprudence.
Yes, the landscape is incredibly varied.
So we have this vast branching tree. But the real question for you, the listener, is how do these different branches actually affect a person's life? Because this isn't just academic trivia.
Far from it. It has real-world consequences.
Exactly. Let's get into a deep dive of the differences. Let's contrast the Sunni and Shia sects on a few major, highly consequential issues. Let's start with marriage.
A critical difference, and one that really highlights the divergence in primary texts. Under Shia law, specifically the Jafari school, there is a concept called muta.
Muta.
This is a temporary marriage. It is a legally binding marriage contract that is created for a fixed, specific period of time.
Like how long?
It could be a month, a year, or a decade. Once that time period expires, the marriage automatically dissolves without the need for a divorce.
Now hold on. A temporary marriage. What was the historical logic behind that, and how is it viewed today?
Historically, it was practiced in pre-Islamic Arabia, often utilized by merchants or soldiers who traveled far from home for long periods.
Okay.
The Shia legal perspective maintains that the Prophet permitted it, and it was never explicitly, permanently abrogated by divine decree, so it remains a valid legal option today.
And the Sunni perspective on muta.
Sunni law entirely rejects muta. They consider it completely invalid.
Completely.
Yes. The Sunni legal consensus is that while the Prophet may have temporarily permitted it during early military campaigns, it was definitively and permanently forbidden later in his life.
So no expiration dates.
For a Sunni Muslim, marriage is fundamentally a permanent contract. Any marriage with a built-in expiration date is void from the start.
There's also a difference in how a regular permanent marriage is formed, right?
Yes. Sunni law requires the physical presence of at least 2 adult witnesses at the exact moment the marriage contract is signed or verbally agreed to.
At the exact moment.
Without witnesses present, the marriage is irregular or invalid.
And Shia law.
Shia law states that while witnesses are highly recommended for societal proof, their presence at the actual ceremony is not strictly mandatory for the religious validity of the marriage itself.
So that's a huge procedural difference. Okay, what about divorce? Let's talk about triple talaq.
Historically, this was a massive distinction. Triple talaq is the practice where a husband pronounces the word talaq, which means divorce, 3 times in one sitting to effect an immediate, irrevocable divorce.
Just boom, done.
Yes. Classical Sunni law, specifically the Hanafi school, recognized this practice as legally binding, even if they viewed it as sinful.
Though, as we mentioned earlier, it's crucial to remember that this specific practice has now been outlawed by secular statute in India.
Right, the 2019 Act.
But what's fascinating is that under classical Shia law, Triple talaq pronounced in one single sitting was never considered legally valid in the first place.
Never. The Jafari school required a much stricter, more prolonged process. A divorce had to be pronounced over a period of months in the presence of specific witnesses, allowing ample time for reconciliation.
So one angry outburst of 3 words did not end a marriage for a Shia Muslim.
Exactly. It required deliberation.
And then there is inheritance. I've looked at the inheritance tables, and it seems incredibly complex.
It is the most mathematically and structurally divergent area between the two sects, and it fundamentally changes the economic reality of families.
How so?
Well, Sunni inheritance law is largely based on a tribal structure. It follows a system of fixed Quranic shares for immediate family, but whatever is left over the residue goes to a category of heirs called residuaries.
Let's avoid the jargon for a second. What exactly is a residuary?
Essentially, residuaries are male agnates. Think of a family tree where you only trace the lines upward through the fathers and grandfathers, uncles, male cousins on the father's side. This is a remnant of the pre-Islamic Arabian tribal structure, where the defense of the tribe and the financial burden of the extended family fell to the sword-bearing males. Therefore, the wealth stayed within the male tribal line.
Okay, so under Sunni law, wealth tends to disperse outward to the extended male family.
Exactly. Furthermore, classical Sunni law generally does not recognize the doctrine of representation. Meaning, if a grandfather has a son, and that son has a child, a grandson, if the son dies before the grandson is essentially cut out of the inheritance.
Wait, really?
Yes. When the grandfather dies, the grandson does not step into his deceased father's shoes to inherit. Instead, the inheritance goes to the surviving uncles.
Wow. That is a harsh reality for that grandson. And the Shia approach.
The Shia approach has a completely different foundational logic. It relies heavily on blood ties, the doctrine of proximity. They largely abandoned the old Arabian tribal agnatic system and focused on the nuclear family. Whoever is closest in blood to the deceased, whether male or female, inherits, entirely cutting out distant uncles or cousins.
So they prioritize the immediate family unit over the extended tribe.
Yes. And crucially, they do allow representation. So in that previous scenario, the orphan grandson would step into his deceased father's shoes and inherit his share from the grandfather.
That feels much more intuitive to modern sensibilities.
It does. Furthermore, they frequently utilize the doctrine of rad, or the return.
Let's explain the map on the doctrine of return because it perfectly illustrates the difference. Let's say a man dies, leaving behind a widow and 1 daughter. No sons.
Okay.
Under the fixed Quranic shares, the daughter gets 1/2 of the estate. The widow gets 1/4. That leaves 1/4 of the estate just sitting there, unallocated. What happens to it?
Under classical Sunni law, that remaining 1/4 would likely be sought by a distant residuary relative, say, a cousin of the deceased father.
So the wealth moves outward to the male line again.
Yes. But under Shia law, applying the doctrine of rad, that remaining 1/4 goes back to the closest blood relative. It returns to the daughter. Her share increases.
The outcomes for families are drastically different based purely on which school of law applies to them.
Totally different economic realities.
So what does this all mean for you, the listener? Picture a family court judge in Delhi. A family walks in to file a dispute over a multi-million rupee estate.
Okay.
That judge can't just open a generic book of Muslim law. They have to first conduct an inquiry. Are you Sunni or Shia? If you're Sunni, are you Hanafi or Shafi?
Exactly.
It's a mind-bending reality. The judge has to be an expert in 6 different mathematical frameworks depending on the specific sectarian affiliation of the people standing in front of them.
It requires an incredible amount of legal literacy and cultural sensitivity from the secular judiciary. The courts actually have to look at evidence, family custom, sectarian affiliation, religious declarations.
Just to figure out where to start.
Just to establish jurisdiction and determine which set of rules to apply.
So we've established that a judge needs to know your school of thought. But the rules don't just change based on your sect. They change based on where you are and what you believe.
Geography and faith.
Right. What happens when a Hanafi Muslim from India moves to a Shia-majority neighborhood in Canada? Or what happens if someone simply stops believing? This is where the friction gets intense.
It's the intersection of private law and public borders.
Let's explore borders and beliefs, domicile and apostasy. Let's start with domicile. Now, we all know domicile generally means the place you intend to live permanently, but how does that interact with personal law?
It creates a massive conflict of private international law. Domicile is physical presence combined with the intent to reside indefinitely. It is the legal anchor for your personal rights.
So let's use a hypothetical. An Indian-Muslim couple, married under Hanafi law in Mumbai, permanently moves to Toronto, Canada, intending to stay there forever.
The moment they establish a Canadian domicile, the legal lens shifts. The Indian courts will say, "You are no longer governed by Indian interpretations of Muslim personal law. You are governed by the laws of your domicile."
Which means if they want a divorce, they have to navigate the Canadian legal system.
Which might not recognize certain aspects of their original Islamic marriage contract.
Or might enforce property division in a way that totally contradicts Islamic inheritance laws.
Exactly. Changing your domicile doesn't just change your tax bracket. It can completely rewrite the legality of your marriage, your capacity to divorce, and how your wealth is distributed upon death.
That's wild.
If an individual has property left in India but is domiciled in Canada, the Indian courts generally apply the law of the Canadian domicile to determine who inherits the movable property. It's an incredibly complex web.
Okay, so that's moving across physical borders. But what about moving across spiritual borders? Let's talk about apostasy, or conversion out of the faith, because this is where we see one of the most stark, dramatic contrasts between classical medieval interpretations and modern constitutional reality.
Yes, the classical Arabic legal term for apostasy is ridda, and you have to understand the historical context.
Right. Take us back.
In the ancient and medieval world, religion and the state were identical. Citizenship was defined by faith.
Okay.
Therefore, apostasy wasn't just viewed as a personal change of heart or a private spiritual crisis. It was viewed legally as an act of treason against the state and the community.
Treason. That explains the severity of the classical rulings. Because under classical Muslim law, if a husband becomes an apostate, if he renounces Islam, the marriage is immediately automatically dissolved.
Instantaneously.
Yeah.
It's an immediate civil death in the eyes of the classical law. The contract is shattered.
But interestingly, if a Muslim wife converts to another faith under classical law, dissolution is not automatic unless the marriage becomes totally unviable. Why the gender difference?
Again, it traces back to the socio-legal structure. A husband's apostasy was seen as a fundamental breach of the contract that severed his legal right to head the Muslim household.
And for the wife?
A wife's conversion was sometimes treated as something that could be remedied or managed within the household, or at least didn't immediately destroy the civil contract in the same existential way, unless it made cohabitation impossible under Islamic norms.
And there were other penalties too, right?
Oh, yes. Classical apostasy led to severe consequences across the board, complete loss of inheritance rights, massive social ostracization, and in classical penal law, capital punishment.
But here is where we hit the brakes. Because you, the listener, do not live in an ancient empire. You live in a modern world.
Thankfully.
If you are in India today, those medieval rules collide head-on with a secular constitution. What is the modern legal approach to conversion?
This is a crucial area of harmonization. India is a secular democratic state. The classical civil and penal penalties for apostasy are simply not applied because they fundamentally violate constitutional protections.
Specifically, Article 25 of the Indian Constitution, which guarantees the freedom of conscience and the right to freely profess, practice, and propagate any religion. You cannot legally penalize someone for changing their mind about God.
Exactly. And the legal groundwork for this actually predates the Constitution.
Really?
Yes. The British East India Company, when they were administering personal laws in the 19th century, found the classical rules on apostasy deeply problematic for their administration.
So what did they do?
They passed a landmark piece of legislation, the Caste Disabilities Removal Act of 1850.
The 1850 Act, what did it do?
It explicitly stated that renouncing a religion or being excommunicated from a caste cannot result in the forfeiture of any civil rights or property rights.
So under modern Indian law, if a Muslim man renounces his faith, the classical texts say, you lose your inheritance in your family. But the Indian secular court, armed with the 1850 Act and the Constitution, says no, you keep your property. Your fundamental civil rights remain intact.
If we connect this to the bigger picture, what we are witnessing is the profound tension and the ultimate harmonization between a traditional text-based personal law system and a modern rights-based secular constitution.
It's an incredible balancing act.
The courts in India act as a bridge. They uphold Muslim personal law in matters of family, but they flatly refuse to apply any classical rule that violates fundamental human rights like equality and freedom of religion.
They use some specific principles for that, right?
Yes, they apply what they call principles of justice, equity, and good conscience to smooth over the rough medieval edges.
Speaking of navigating constitutional values in personal law, let's look at the absolute center of family law. The reason most people interact with these legal structures in the first place, and where all these rules about belief and contracts come to a head, marriage.
Everything in Muslim personal law ultimately revolves around the concept of marriage, or nikah. And the very first thing we must establish, which surprises many people accustomed to other religious traditions, is the fundamental legal nature of a Muslim marriage.
Which is?
It is not a sacrament.
Not a sacrament. It is a civil contract.
Yes. In classical Hindu law or Catholic doctrine, marriage is often viewed as an unbreakable, sacred, spiritual bond, a sacrament ordained by God that humans cannot easily sever.
But in Muslim law,
nikah is a purely civil contract between two parties. It has a spiritual dimension, of course, but legally, it is a contract.
and because it's a contract, it has specific, non-negotiable requirements to be valid. You need an offer, ijab, from one party, and a clear acceptance, qabul, from the other.
And it has to happen in one sitting, so there's no ambiguity.
Right. And crucially, there's the requirement of dower, or mahr.
Mahr is incredibly important, and it is frequently misunderstood.
Yeah, I've heard people confuse it with dowry.
It is not a dowry, which is money the bride's family pays to the groom, and it is not a bride price where the groom buys the bride from her father.
So what is it legally?
Mahr is a specific sum of money or property that the husband legally promises to pay directly to the wife in consideration of the marriage.
To the wife directly, not her family.
Exclusively to the wife. It is an absolute essential requirement of the nikah contract. It belongs entirely to her.
That's a huge distinction.
It is a mark of respect for her independence, and practically it serves as a vital financial security net for her in case of divorce or the husband's premature death.
And there are two types of mahr, right? Prompt and deferred.
Yes. Prompt mahr is payable immediately upon marriage on demand by the wife.
And deferred.
Deferred mahr is payable upon the dissolution of the marriage, either by divorce or death.
Ah.
And in modern times, a substantial deferred mahr acts as a very practical deterrent against hasty or arbitrary divorces by the husband, because a divorce instantly triggers a massive financial debt.
Oh, that's smart. It forces you to think twice.
Yeah.
Okay, so we have a civil contract with a built-in financial security mechanism. But who can actually enter into this contract?
That's where things get complicated.
Yeah, when you look at the mechanics of interreligious marriage, you hit a wall of incredibly strict rules. And once again, the rules change depending on whether you are Sunni or Shia, and crucially, whether you are a man or a woman.
It is a highly gendered and sectarian area of the law. Let's look at the Sunni rules first, specifically the Hanafi school.
Under Sunni law, a Muslim man is permitted to marry a Kitabi woman. Kitabi translates to people of the book, which specifically refers to Christians or Jews.
Yes. Under Sunni law, a man can legally marry a woman from these Abrahamic faiths, and she is not required to convert to Islam. The marriage contract is perfectly valid.
But if we flip the genders, a Muslim woman cannot marry a non-Muslim man at all, even a Kitabi.
That's right. Under classical Sunni law, a Muslim woman's marriage to any non-Muslim is considered strictly prohibited.
But hold on, let me push back on this. If nikah is purely a civil contract, like a business deal, why does the religion of the counterparty matter so much more for women than for men? What is the legal logic there?
The classical legal logic is rooted in the patriarchal social structures of the time. In historical Islamic societies, the lineage, the religion of the children, and the headship of the household followed the father.
Okay, I follow.
The jurists reasoned that if a Muslim man married a Christian woman, the children would still be raised Muslim, and the household would remain under Islamic legal norms.
But if a Muslim woman married a Christian man?
They feared she and her children would be subsumed into his religious and legal culture, thereby losing them from the Muslim community. It was about preserving community boundaries through patriarchal lineage.
Okay, I understand the historical rationale, even if it deeply clashes with modern egalitarian values. So that's the Sunni view. What about the Shia view?
The Shia Jafari view is much stricter across the board. According to classical interpretations, a Shia Muslim, whether man or woman, cannot enter into a permanent marriage with a non-Muslim at all.
Not even a kitabi.
Even a man marrying a kitabi is considered legally void.
Void. The legal term is batil,
Yeah.
right? Meaning it has absolutely no legal existence. It's a nullity from day one. So if a Shia Muslim woman marries a Christian man in India,
The legal position under Muslim personal law is unequivocally clear. Because she is a Muslim woman marrying a non-Muslim man, the marriage is legally void, batil. It doesn't exist. Unless he converts to Islam, that specific contract cannot be validly formed.
but again, we live in a secular democracy. People fall in love across religious lines every day. What is their option?
If they want a legally recognized marriage without either party converting, they have to step completely outside the realm of Muslim personal law.
And do what?
They utilize the secular alternative provided by the Indian state, the Special Marriage Act of 1954. This allows any two individuals to marry regardless of their religion, creating a purely civil, secular marriage governed by state law, not religious law.
Okay, so let's say you have a valid contract. You are married, but a dispute arises. How does someone actually get what they are legally owed? Say a wife wants to claim her unpaid Mahr, or a widow is fighting for her inheritance share. How is this law actually enforced in the real world?
Broadly, enforcement happens through two distinct mechanisms: judicial enforcement and customary enforcement.
Judicial enforcement is the formal, modern route. You hire a lawyer and go to a civil court.
Yes. The modern Indian legal system allows you to enforce Muslim personal law through regular state courts. A woman could file a civil suit under the Civil Procedure Code for the recovery of her dower.
And if it's an emergency.
Alternatively, if she needs immediate financial relief, she might claim maintenance under Section 125 of the Criminal Procedure Code.
Now, Section 125 is interesting because it's a secular law, right?
It is. It's a rapid relief provision available to women of all religions to prevent destitution. A Muslim woman can utilize this secular tool alongside her rights under personal law.
And the judges have to navigate both.
When cases go to the formal courts, the secular judges interpret the Islamic principles using the strict rules of the Evidence Act and generations of judicial precedents.
That's the formal state apparatus.
Yeah,
It's powerful, but it's slow and expensive.
very slow.
But then there is customary enforcement. In vast parts of rural and semi-urban India, enforcement often happens through panchayats, informal village councils, or through a qazi, a local religious authority and judge. Now wait, I need clarification here.
Sure.
If a qazi gives a ruling today, it isn't legally binding in a modern civil court. The state police aren't going to enforce a qazi's order. So why do millions of people still use them? Why not just go to the judge?
It's a brilliant question, and the answer lies in understanding how society actually functions and a vital concept in Islamic law called possession.
Possession.
In many Islamic legal transactions, like executing a gift or hiba, or creating a charitable trust, waqf, or physically securing an inherited piece of land, actual physical possession and control over the property is critical to validating the legal right.
So the old saying holds true: possession is 9/10 of the law.
Precisely. Now imagine a bitter dispute in a village over an inherited orchard. Going to a formal civil court in the city takes years.
Decades sometimes.
It costs exorbitant legal fees and destroys extended family relationships. A panchayat, or a local qazi, offers highly accessible, culturally resonant mediation.
Even if it's not state-backed.
The qazi's ruling doesn't carry the coercive power of the state police, but it carries immense social and religious weight.
So if the qazi issues a ruling based on the Quran, and the community respects that qazi, the community itself enforces the ruling socially.
Exactly. The family complies because of faith and social pressure. Physical possession of the orchard is transferred smoothly. The family ties remain somewhat intact, and the dispute is resolved in weeks instead of decades.
That's incredibly efficient.
It relies on the community's shared belief in the legitimacy of the system. It is a highly effective form of alternative dispute resolution deeply rooted in shared faith.
That completely reframes it for me. The qazi isn't just a lesser, unofficial version of a state court. It's a parallel system of social harmony.
It is the living law operating outside the courtroom.
We have covered an unbelievable amount of ground today. We have essentially built that skyscraper from the ground up.
We truly have.
Let's do a brief recap. We started with the blueprints, the primary sources. We saw how the 80 legal verses of the Quran and the practices of the Sunnah were expanded by the scholarly consensus of ijma and the rigorous analogy of Qiyas,
And we saw how those divine roots adapt to reality through secondary sources like local custom and modern Indian legislation.
like the 1937 Sharia Act and the 2019 ban on triple talaq.
Then we explored the branching paths, we examined the profound historical and geographical differences between the Sunni schools,
Like the flexible Hanafi school born in cosmopolitan Kufa and the literal Hanbali school.
and we contrasted them with the rationalist Shia schools, looking at how those ancient divides fundamentally alter modern rules around temporary marriage and the intricate competing mathematics of tribal versus nuclear inheritance.
We tackled the complexities of modern borders and beliefs, how your physical domicile dictates your legal jurisdiction, completely rewriting your family law if you move to Canada.
And how the secular Indian constitution, through tools like the 1850 Caste Disabilities Removal Act, steps in to protect inheritance rights in cases of conversion and apostasy.
Overriding the harsh classical penalties that treated apostasy as treason.
And finally, we looked at the core of it all, the civil contract of Nika, the financial security of Mahr, the strict boundaries of interfaith unions.
And the fascinating dual system of enforcing these rights through both formal secular courts and the socially powerful informal customary mediators like quasis.
It's a lot to take in.
It is. But for you, the listener, understanding this framework is so much more than just an academic exercise. Whether you are a legal professional, a student, or just an insanely curious person trying to understand the world, grasping how Muslim law operates in India is about understanding how a multicultural society actually functions.
Very true.
It shows how a modern nation attempts to respect vastly diverse, ancient religious identities while still maintaining a unified, overarching constitutional legal system. It is a masterclass in the friction and the harmonization of human beliefs.
It shows that law is not just a list of rules, it is the codification of a community's deepest values, constantly adapting to survive the test of time.
Which leaves us with one final provocative thought to ponder. We discussed how informal systems like qazis rely on community trust to function. But today, rising legal literacy is changing the landscape.
Rapidly.
People, especially marginalized voices and women, know their statutory rights better than ever before. As digital records expand and modern formal courts become more accessible, what happens to the qazis and the panchayats?
That is the question.
Will these informal, centuries-old mediators eventually disappear entirely into the pages of history, replaced by secular judges? Or will they evolve to work alongside the state courts in entirely new hybrid ways?
A living architecture is always under construction. The blueprint is never truly finished.
We started by talking about static blueprints and living buildings. It turns out, Muslim law in India is a skyscraper where the foundation was poured 14 centuries ago, but the residents are still actively designing the upper floors, constantly balancing the immense weight of history with the relentless winds of the modern world. Thank you for joining us on this deep dive. We'll see you next time.